All right. So we continue in from we left off with the estate law, different case laws like that. Um, so we're dealing with a case law. Once again, it's connected to Article 4, Section 1. We can attach this as far as res judicata to support our position. So this case is First National Bank of Montgomery. That was the plaintiff in this case. The defendant was Jerome Daly. And we're going to go into the judgment and decree. All right. So the above entitled action came on before the court and jury of 12 on December 7th, 1968 at 10 a.m. Plaintiff appeared by its president, Lawrence V. Morgan, right? The president of the bank, obviously, First National Bank of Montgomery, and was represented by its counsel, R. Melby. Defendant appeared on his own behalf. A jury of townsmen were called, impaneled, and sworn to try the issues in the case. Lawrence V. Morgan was the only witness called for. Plaintiff and defendant testified as the only witness on his behalf. Plaintiff brought this as a common law action. The plaintiff brought this as a common law action for the recovery of the possession of Lot 19, Fairview Beach, Scott County, Minnesota. Plaintiff claimed title to the real property in question by foreclosure of a note and mortgage deed dated May 8th, 1964, which plaintiff claimed was in default at the time foreclosure were started. Defendant appeared and answered that the plaintiff created the money and credit upon his own books by bookkeeping entry as the consideration for the note and mortgage of May 8th, 1964, and alleged failure of consideration for the mortgage deed and alleged that the sheriff's sale passed no title to the plaintiff. We're reading the transcripts, right, of a case. The issues tried to the jury were whether there was a lawful consideration. And once again, it's a reoccurring theme dealing with case law. And Roz Leone and y'all just read about contract law, so y'all should know what consideration is, right? That's dealing with something of value in a contract. And whether defendant had waived his rights to complain about the consideration, having paid on the note for almost 3 years. Mr. Morgan admitted that all the money or credit which was used as a consideration was created upon their books, that this was standard banking practices. So as you can see, clearly, if nobody knows why we're going into this case law, because the last couple of weeks we've been talking about what's consideration, what's money, what's notes, what's a promissory note, etc. So we're reading a transcript that we can use if we're ever in a situation similar. Right. So Mr. Morgan admitted that all the money or credit which was used as consideration was created upon their books, that this was standard banking practice exercised by their bank in combination with Federal Reserve Bank of Minneapolis, another private bank. Further, that he knew of no United States statute or law that gave the plaintiff the authority to do this. Plaintiff further claimed that defendant, by using the ledger book, created credit, and by paying on the note and mortgage, waived any right to complain about the consideration, and that the defendant was stopped from doing so. So far we got the defendant complaining that I never received no money. The bank's saying they're giving me money based on what they marked in their ledger. Oh, we gave somebody a loan. They just wrote it in there. Just bookkeeping, but nothing of value was exchanged. So I hope y'all following this. At 12:15 on December 7, 1968, the jury returned a unanimous verdict for the defendant. Now, therefore, by virtue of the authority vested in me by the Declaration of Independence, the Northwest Ordinance of 1787, the Constitution of the United States, and the Constitution and laws of the state of Minnesota, not inconsistent therewith, it is hereby ordered, adjudicated, and decreed the following. 1, the plaintiff, that's a couple people in here. Boom, boom. All right. So 1, the plaintiff is not entitled to recover possession of lot 19. So here's an order of the plaintiff, the bank, right? That's saying they own the property, not entitled to recover possession of lot 19. Fairview Beach, Scott County, Minnesota, according to the plot thereof on the file of the Register of Deeds office. 2, that because of failure of lawful consideration, so look at the decision, lack of lawful consideration. Whoever don't know what consideration is, look up contract law. See what consideration is. Consideration is something of value, lawful money, right? Or if it's not lawful money, it needs to be agreed upon.
Yeah, we was just reading that.
You feel me? That's divine. That's divine right there, right? You know what I'm saying? So this is a case law to support what y'all study that y'all can use as res judicata. And if y'all missed the beginning, let me just scroll up so you can see the case. This is First National Bank of Montgomery. It was the plaintiff, which was a bank, versus Jerome Daly. And Jerome Daly's argument is that we didn't get no money, no consideration, right? And so it was ordered, adjudicated, and decreed that because of failure of lawful consideration, the note and the mortgage dated May 8th, 1964 are null and void. This is case law. This is stuff we can use, right? That the plaintiff has no right, title, or interest in said premise or lien thereon as is above described. 5, that any provision in the Minnesota Constitution and any Minnesota statute binding the jurisdiction of this court is repugnant to the Constitution of the United States. Or repugnant is just, it goes against the Constitution of the United States and to the Bill of Rights of the Minnesota Constitution, and is null and void, and that this court has jurisdiction to render complete justice in this case. The following memorandum and any supplementary memorandum made and filed by this court in support of this judgment is hereby made a part hereof by reference. And this was decided December 9th, 1968. Memorandum. The issues in this case were simple. There was no material dispute of the facts for the jury to resolve. Plaintiff admitted that in combination with Federal Reserve Bank of Minneapolis, which are for all practical purposes, because of their interlocking activity and practices, and both being banking institutions incorporated under law of the United States, are in the law to be treated as one and the same bank, did create the entire $14,000 in money or credit upon his own books by bookkeeping entry. So all they did was just write, we gave somebody a loan for $14,000, just because they wrote it in their book, but nothing happened. $14,000 was never given to anybody, and that's not consideration.
So what is saying, because it's saying consideration is not to be confounded with motive. Consideration means something which is a value in the eye of the law. So it's because they're dealing with fiat, and that's not legal, lawful money. Is that what it's saying? So
Yep.
Anything that's gonna be, used with fiat is automatically no consideration.
Unless you agree to it.
Right. Contract.
And then it becomes a legal contract because you agreed.
But not lawful. So
No.
there's no morals attached to that.
Right. Yep.
And
Yep. And that's what was ruled upon in this case law. Right. So we can use that based on Article 4, Section 1 of the Constitution. It's a case law that we can use.
stare decisis.
Stare decisis. Yep. And that this was the consideration. Islam, Hanuna, and brother Imani.
Islam, everybody, Islam.
Islam.
So that
Islam.
Islam. So that
Islam.
all right. So that this was that this was the consideration used to support the note dated May 8, 1964, and the mortgage of the same date. The money and credit first came into existence when they created it. Mr. Morgan admitted that no United States law statute existed which gave him the right to do this. Right? Cool. They making stuff up, right? A lawful consideration must exist and be tendered to support the note. See Anheuser-Busch Brewing Company versus Emma Mason, another fly-related case. The jury found that there was no consideration, and I agree. Only God can create something of value out of nothing, right? This is all transcripts in the case, memorandum. Even if the defendant could be charged with a waiver or estoppel as a matter of law, this is no defense to the plaintiff. The law leaves wrongdoers where it finds them. See sections 50, 51, and 52 of Amjur's second actions, quote unquote, on page 584, where it states no action will lie to recover on a claim based on or any manner depending on a fraudulent, illegal, or immoral transaction or contract to which plaintiff was a party, right? Back to contract law. If all the elements aren't intact, then there's no contract. Can be fraudulent activity. We already know about the can be a minor. We already know about the linear, can be one-sided, right? And others, right? All right. Plaintiff Act of, oh, 1 second. Plaintiff Act of creating credit is not authorized by the Constitution and laws of the United States. Is unconstitutional and void, and is not a lawful consideration in the eyes of the law to support anything or upon which any lawful right can be built. Nothing in the Constitution of the United States limits the jurisdiction of this court, which is one of the original jurisdiction with right of trial by jury guaranteed. This is a common law action. Minnesota cannot limit or impair the power of this court to render complete justice between the parties. Any provisions in the Constitution and law of Minnesota which attempt to do so is repugnant to the Constitution or opposite to the Constitution or contrary to the Constitution of the United States and void. No question as to the jurisdiction of this court was raised by either party at the trial. That's fire right there in itself, because now you know you can challenge jurisdiction. They're telling you, but they just decided not to. Both parties were given complete liberty to submit any and all facts to the jury, at least insofar as they saw fit. No complaint was made by plaintiff, and plaintiff did not receive a fair trial. From the admissions made by Mr. Morgan, the path of duty was direct and clear for the jury. Their verdict could not reasonably been otherwise. Justice was rendered completely and without denial, promptly and without delay, freely and without purchase, comfortable to laws in this court of December 7, 1968. Anybody got any questions before I move forward as far as this case? Is this pretty straightforward to everybody?
Yeah, I just wanted to say, is it so they're saying that they did not receive a fair trial, so they didn't get due process law. Does that apply?
No complaint was made by plaintiff that plaintiff did not receive a fair trial.
So it's the fact that they weren't aware that they weren't receiving a fair trial, or they didn't submit it, like they didn't challenge it. Basically, they just like, oh, we just gonna rock with this.
Yeah, yeah, because there was an error. It was, once the jury heard the facts, it was straight up like it was no consideration based on the laws of contract law, you know what I mean?
Yeah.
It was, you know. Yeah. I think there's like the fourth case dealing with this particular issue. If y'all go back to the Wednesday and Friday and Wednesday, there was a couple more that we went over. But I like this one. It's pretty straightforward. So note, there are claims that this case has been nullified, yet its alleged claim of nullity violates Article 6 of the Constitution. Therefore, all claims of this nullity are unconstitutional and nullities themselves. Courts are constituted by authority, and they cannot go beyond that power delegated to them. If they act beyond that authority, and certainly in contravention of it, their judgments and orders are regarded as nullities. They are not voidable, but simply void. And this even prior to reversal. So remember that this court just decided to be constitutional because all these are pseudo courts. If you want to, but that's another layer. But if you have a pseudo municipal court that's getting in a constitutional mode, then they just change the mode of that court to common law, right? But technically, that court in Minnesota, I'm pretty sure it didn't have no delegation of authority from Congress, right? But that's another layer. But that wasn't addressed. That wasn't brought up. That makes sense, right? They went over contract law. The jury was instructed. Well, not instructed. The defendant raised a point that consideration. So really, the defendant, if it wasn't for the defendant opening a common law door in front of the jury probably wouldn't even win in that mode. So that's another area that we need to examine. That we need to know this stuff, because who wouldn't even know about contract law like that? Most people don't. To go in court and be like, it wasn't no consideration. Like, you know what I mean? You know what I'm saying? So we call them genius citizens, especially in this climate of most people being dumbed down. So he kind of did, show some competence, which forced the court to go in a different mode. They do not want you to go to trial on anything that's done. If somebody's competent in law, they're just gonna bluff you out and keep giving you continuances. They do not want you in front of a jury. They want control. They don't want other people in control and hearing your law, because they're gonna be like, okay, this is law. He's not out to lunch. He's telling the truth. You know what I'm saying? So here's a case in point where, we see that's where it's at. All right. So the general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment and not merely from the date of decision, so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle, just as it would be had that the statute had not been enacted. So I think that's even back to penal codes, ordinance, statutes. If it's not in harmony with the Constitution, then it's void on its face. And it actually, when you start going to the federal courts and things like that, and in some matter of fact, state courts, you can challenge the constitutionality of the statute. That's even on their forms. You can check off a box like, why am I doing this? Why am I, moving forward with a case? Because I want to challenge the constitutionality of the statute, which is basically saying that even though it's a municipal code, is not in harmony with the Constitution, so therefore it's void. But that is back to the citizen or the person filing, the competency of the person bringing these issues up. To even know that the statute is not constitutional in the first place, right? You have to know what the Constitution is to even Had that measuring stick. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. Simple, right? It's going against the law of the land. It's not valid. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. All right. Any questions before I move on to HR 25? Fair tax. Also called the Fair Tax Act. All right, so fair tax was a flat tax proposal in 2005, 2008, and 2009 in the United States that includes complete dismantling of the IRS. Think about what I just said. This House resolution was talking about dismantling the IRS. And not back in the 80s. This is around not too long ago. So this House Resolution 25 to promote freedom, fairness, and economic opportunity. And once again, it's a House resolution, so it's res judicata. We can use this as res judicata connected to Article 4, Section 1, right? So to promote freedom, fairness, and economic opportunity by repealing the income tax. So they're talking about repealing taxes. So now the reason we're going over this is we're talking about taxes now. Another way to skin the cat dealing with taxes, right? Abolishing the Internal Revenue Service and enacting a national sales tax to be administered primarily by the states. All right, all the people involved in the House of Representatives situation this was 2019 actually, so this wasn't that long ago, right? So this is what it's talking about. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. Congressional findings. A, Congress finds the federal income tax retards economic growth and has reduced the standard of living of the American public. First reason why I want to get rid of these taxes. 2, impedes the international competitiveness of the United States industry. 3, reduces savings and investment in the United States by taxing income multiple times, right? We got federal, state taxes coming out people's check, right? So this is a reason why I just want to get rid of it. 4, slows the capital formation necessary for real wages to steadily increase. 5, lowers productivity. 6, imposes unacceptable and unnecessary administrative and compliance costs on individual and business taxpayers. 7, unfair and inequitable. 8, unnecessarily intrudes upon the privacy and civil rights of United States citizens. And we get whatever, all that United States citizen talk, we're using it for what we want to use it. We're using it for to lay the foundation on not being taxed. Amongst the other stuff we know, this is just supplemental extra information. 9, hides the true cost of government by embedding taxes in the cost of everything Americans buy. 10, is not being complied with the satisfactory levels and therefore rises tax burden on all law-abiding citizens and impedes upward social mobility, right? Findings related to federal payroll taxes. Congress find further that the Social Security and Medicare payroll tax and self-employment taxes. 1. So this, remember all these things, when you get your check, there's multiple types of taxes coming out, right? All this is not supposed to be. 1, raise the cost of employment. 2, destroy jobs and cause unemployment. And 3, have a disproportionately adverse impact on lower income Americans. Findings related to federal, state, and gift tax. Congress finds further that the federal, state, and gift tax, 1, force family businesses and farms to be sold by the family to pay such taxes. 2, discourage capital formation and entrepreneurship. So all this stuff is derogatory, right? Don't everybody want to be an entrepreneur? 3, foster the continued dominance of larger enterprises over small family-owned companies and farms. 4, impose unacceptably high tax planning costs on small businesses and farms. So this is all the reasons why. So this is HR 25, whoever didn't catch that. And we can utilize this for another reason why taxes, you ain't supposed to be taxed. So I call this supplemental. But primary, I go to the Constitution, Article 1, where it states what? Only Congress can levy taxes, right? The IRS is not Congress. All right. Any questions before we transition to the next segment?
What about yours?
So this would be like considered like kind of like they stuff, you know what I'm saying? Like we showing them they protocol like, hey, within your own colorful confounds, y'all not supposed to do this on top of the ancestral part of it of them. But even within your own protocol right here, y'all not even following your own shit.
Right. Yeah. We want to hit them with the rights of indigenous people, Constitution, they stuff.
Just in case they play like, oh, well, we don't recognize that. Well, do you recognize your own right here? Because this is
Yep.
Which one is it?
Right. Yep. Anybody else before we transition? All right, so we're transitioning to the Weiss's Concise Trustee Handbook. Pretty sure most people are familiar with this. All right, trust basics. First, it must be understood that any trust, regardless of many designations applied to them, is in its most basic sense a property interest held by one person, the trustee, at the request of another, the settlor, for the benefit of a third party, the beneficiary. The classification applied to a trust is based upon its mode of creation, in which it may be created either by act of a party, express or implied, or by act of the law resulting of constructive. Without getting into the various subclasses of express and implied trust, the basic difference between one created by express act or a party and one created by implied act of a party is that the former is stated fully in language or oral or written, while the latter is inferred from the conduct of the parties. These are very generalized definitions, so presented for one of space, since there are many intricacies concerning the true meaning of the term implied. It has been shown that, in a sense, the classification of express trust can only be applied based on what is implied by the language of the instrument giving rise to the trust. So we won't get into that. Our focus is on a particular written express trust type. And even though the above definition is essentially accurate, it is not, it does little to define the express trust as it is known in the fullest sense under the protections of common law. So when they're saying a trust protected under common law, we're back to contract law. No obligations placed on contracts. No obligations placed on a trust. Especially if all the elements are there and it's not a fraudulent contract. The contract is essentially the law. So we're talking about implied trust, which they're saying they're not going to go into in detail. but we could use our common sense. We talk about actions of people just doing it. Like, okay, we're gonna work out tomorrow. We're not gonna write it down like, oh, let's write this down. We're all gonna work out tomorrow. Everybody sign it. That will be what? Express. Implied will be just doing it. We're gonna do this, and we just did it. So people can say, oh, they're working out. That's an implied, right? There's no need to write it down. We just gonna do it.
One's written, one's verbal.
Right, exactly. Right. All right, so express trust under the common law. The most adequate definition of the express trust is to be understood from the earlier case law, which has been eloquently summed up and restated into a clear, concise definition by Alfred D. Chandler, Esquire. In the first of his two papers submitted as a report to the tax commissioners of Massachusetts on voluntary associations as part of a legislative investigation into their economic effect on the state in 1911. At page 6, he offers the following definition, quote, express trust put the legal estate entirely in one or more persons, while others have a beneficial interest in and out of the same, but are neither partners nor agents. This simple, adequate common law right, any person or group of persons, sui juris, may exercise. And it's interesting how this is not a Moorish situation, but it's using the term sui juris. I'm not sure if anybody heard of that. But you know law, sui juris, right? Juris, you're a jurist. You know law, you're competent. The trustees issuing certificates of beneficial and capital interest divided into shares, as well as issuing bonds and other obligations as freely as they open a bank account, have a passbook, and draw and circulate checks, or make whatever contractual relations are allowed to persons as a natural right. So once again, you know, when people start creating family trusts, them, their significant other, the beneficiary, you would construct it and then just keep living it. Every time y'all accumulate something, it's called reconvey into the trust. Now y'all gonna accumulate trust assets as y'all go on in life, and that'll be passed down to the heirs, right? Anything happen to you or whatnot, whoever, and y'all start accumulating big things, that's like, oh, where this stuff supposed to go to? Oh, it's a trust. Any court, pseudo court, real court, you can go to that and have them enforce it. It's like a will. A trust is just a will that you can execute while you're still alive. So you always want to have all your affairs straightened out, especially as you start getting industrious and accumulating more things, right? What becomes clear from this definition is that the express trust is not merely a property interest held, but one for the benefit of another, but rather a private contract, right? That's why I keep stressing Article 1, Section 8. No obligation shall be placed on contracts. That really should be called the trust law clause. Like how they call Article 6 the supremacy clause. Think of that as the trust clause. When you hear that, no obligations placed on contracts, right? A private contract for holding a divisible property interest accepted by one at the offer of another, having full power to do whatever he may naturally do for himself as an individual sui juris for the benefit of a third party of his choosing. What has been created here is a trust organization. A trust organization, purely sui juris. As a general proposition, it may be asserted that one who creates a trust may mold it into whatever form he pleases, and that whatever one may lawfully do himself, he may authorize another to do for him. without receiving any benefit, privilege, or franchise from any government or other outside party. Right? So the trust creates an insulation, a line in the sand. And therefore, they owe no duty to any government or outside party to the extent that no common law criminal or civil wrong is the purpose of the contract. If this is so, then the trust is afforded all the common law protections ordinarily given to private contracts, right? Private, that lingo, private. Where do they use that lingo, private, in the Constitution? Fourth Amendment, Fourth Bill of Rights. Private property got protection under the Fourth Amendment. Particularly the obligation of them. Now, the question is whether the parties to the contract are truly acting sui juris of their pure, unadulterated common law rights, because if the parties have prior contractual obligations, which grant outside party a vested interest in all their personal relations, then the contract has acquired a third party overseer and interventor. So once again, sui juris. Make sure you don't have any incompetent contracts that's out there. And if you do, nip them in the bud so you can move on to this space. I'm going to stop right here. Open the floor for questions. We'll pick it up with declaration of the express trust next time. But did anybody have any thoughts on what was read tonight? Please put them out there.
Good job and very well explained.
Wow, wow. Anybody have any questions, thoughts before we close out?
No, so far,
Not
so
just yet for me. I'm sorry.
Pretty straightforward. Everybody pretty clear so far?
Mm-hmm.
yeah, just got to go over like more words. I'm talking about and just making sure that I understand each word that holds some weight when you communicating with these corporations.
And you see the reoccurring theme, consideration. That's a big deal, because yeah, it's common law. That's contract law rather. It's common law as well, but it's when you study contract law, people that go to school for that, they just go to school for contract law. And on everybody's own time, they can look up the 10 maxims of law as well. It goes hand in hand with this. Yeah, man.
Yeah, that's divine though. That me and Rosleon was, because he kept telling me about consideration as we was reading this document. Because we kept coming to that word, and he kept reminding me, look, consideration. And then as soon as you get on, that's the first thing that we hear. I was like, oh, ain't that something?
Mm-hmm. And I'm looking at this small print right here too. We got a little case laws up in here, right? Berry versus McCourt, 1965 case. The court held that express trust is a contractual relationship based on trust form, right? It was held that any law or procedure in its operation denying or obstructing contract rights impairs the contractual obligation and is therefore a violative of Article 1, Section 10, right? Right there. That's why I said Article 1 needs to just be, Article 1, Section 10 needs to be the trust clause. That's why I said it like that, because that's what it all goes back to contract law, protection of your right to contract. So you need to know how to contract, right? And we also know other elements in Article 1, Section 10 dealing with the lawful money. You notice how it's all in the same section? It's talking about gold and silver coin. It's to use, because that's lawful money. We're back to consideration. It's all in the same article and section.
Right.
You know what I mean? So yeah. I'm gonna do one more round for thoughts and we'll close out.
You said look up the 10. What?
The 10 maxims of law.
And maxims of law.
Matter of fact, I'll just do
And the
it.
other thing that you had, my fault.
No, go ahead.
I was trying to see the rights of indigenous people. Is that like another like a case that you could look at, or what was that?
Yeah, you can use that as a precedent, as a binding contract. When you look up the Inter-American Declaration on the Rights of Indigenous People, and you read the preliminary on say how the United States contractually is embedded with the Organization of American States, which created a charter for rights of indigenous people. So
Going to,
Okay.
right, then the other goes into the contracts, which is, they said Article 1, Section 10. Um,
yep, Article 1, Section 10. Let me just at least just, I'm gonna type in. Can you everybody see the screen as far as me typing 10 maxims of law?
This front a little bit.
Can you do you see this Newsy? I mean, I see Newsy on the screen, but Brother Imani,
Yeah, I said yes, sir.
say 10 maxims of law up here.
Yes.
Okay. So that's how you would type it in and go through multiple search engines and just go through it. Just one example. It'll take you, go through it, read it in its entirety.
Hey, go back to the search engine, Muffy, and put in the PDF. That's one of them, but just put the PDF in. You ain't got to click. Let me see which ones pop up.
Yeah.
Scroll down a little bit. Keep going. The Mac right there. Okay. So a couple of those like the maxims of law. Got one. Is it this one? Yeah, this is the words one. This is break down the words of certain, like basically from Latin, and because the maxims is the common law. They got the common law of maxims. Then they got another. It's like basically how we was talking about stare decisis, and it's like supreme maxims that go hand in hand with that. It's kind of crazy. I liked it, but I was trying to see if it was gonna pop up on the computer with just looking in the PDF. This ain't it. Go back to the PDF search for me.
But this is still good to read.
Mhm.
It gives you background
On the issues of it. Yeah.
Yeah. And then the other one is going to just simply say like 1, 2, 3, through 10, each bullet point. Trying to think of a good one he could see. Right?
The collections ones, right? I know that's the moving traffic mastering. That's a commercial code.
Oh, here we go. Here's a simplified one. So 1, a workman is worthy of his hire. 2, all are equal under the law. 3, in commerce, truth is sovereign. So the law, the exactness of the law trumps stuff that's not law, right? 4, truth is expressed in a form of an affidavit, right? An unrebutted affidavit stands as truth in commerce. So that's why, like, when we, as Moors or nationalities, have our position, or any position in law, we're saying, here's my affidavit on what the law is, respond point for point on what I did wrong, right? That's where that comes from, these maxims and default and all that stuff. So let's pull up all 10. Oh, I ain't pulling it up. That's crazy. But yeah, just play with it, and you'll find one search engine that I bring all 10 up. But you get the point. Here's
All
seven,
right.
here's seven
Hey,
for you.
no, look, I got it more. Put in, I think it's jurisdictionary. Go to the top search bar, put in jurisdictionary. Nary though, the dictionary, yeah. Nary. And put it together. Yeah. No, put the whole word to no, put that whole word spell. I got it in here. It's like jurisdictionary together. Yeah, there you go. And then see if it pop up like that. No. Get jurisdictionary. Where you go? PDF jurisdictionary flow. Right. I think that was it.
I think what it is, I'm on Bing, but if you go to Google Chrome, it'll be more comprehensive, like laid out for you. But like I say, y'all just play with it. I just read 7 of them, so you get the point, right? So just kind of play with it till you find it. Matter of fact, I got some PDFs that I could email to you too, the full 10, because just like how I can't find the Kingdom of Morocco no more, talking about it's 1956, they just switch some shit up. They gonna switch some shit up once we keep chiseling away at this stuff, informing people about it. They make it a little harder and harder. I can't even find a PDF of the Black's Law Dictionary like I used to it. That's why I'm glad I got this stuff archived. You know what I'm saying? So, but yeah, any other questions for the close out here?
Nah, that's crazy.
Yeah, ain't it?
Nah, 'cause I'm over here like I found another little. It's like a lawsuit flow chart, but it's like this is not jurisdictionary. The stuff that I just punched in, because matter of fact, I can show you the one from my PC, and
They
I can't even see myself, so I don't even know what's showing right now.
can't be this one. Shit.
There we go.
Oh, here we go. I found one.
Switch this, John.
Yep, here go. Yep, here go all 10. Wait, no, wait. That's something different. It's something different.
All right, so maxims of common law. Put that in on your search engine more. Try that one. And maxims of common law. So this one break down a lot. It goes into details of those same 10 maxims that Mafi just presented. And out of that 7. So when I don't know if you can see it, but so as you go through these maxims as brief statements, it gives you like the actual, like a story of each maxim, so where you kind of comprehend it a little bit, and then it'll break down why it sits fit for the common law. You know what I'm saying?
Oh, here we go. Here we go. We on. Here's a good one.
So,
This a good one too.
oh yeah, that's the one too. Yeah.
And then it ties it into the Bible. So I like this one. I think it's the one I got in my email too. So
I got the same one. Yeah.
Workman is worthy of his hire. Matter of fact, you know what? Let me leave this up for next time. But yeah,
Snap.
You feel me? All right. Let me just scroll through so y'all can take pictures. I'm gonna take my time and scroll through it. So here are the first 3. All right.
Oh yeah, you gotta hold on.
All right.
That one, number 3 wasn't all the way.
Okay.
Yeah, I need to see the whole joint. Now I can't see number 1. Okay, dang, it's kind of like, yeah, between the rock and a hard place.
Yeah. You got it?
Yeah.
All right, I'm gonna scroll through slowly.
All good.
Good. Y'all breaking up.
Yep.
Okay.
Yeah. That's right. All right. So that's 5, 6, 7.
Mm-hmm. So that's the 10. And that's the origin. Most of the principles are rooted in. But so everybody good with this? Everybody got a snapshot of this?
Mhm.
Perfect.
Perfect. Okay. All righty. Well, I'm gonna go ahead and close out. Hopefully everybody have a beautiful night, rest of their night, and I'll see y'all on the holy day.
Islam, thanks for sharing with us again.
Islam,
Yeah,
thanks.
thank you, G.
Peace, peace.
Islam.
Thanks.
Peace and love. Islam.
Night, family.
Slime.
Night.